G'day Year 12 and welcome to another YouTube lesson. Today we're going to be taking a look at human resources, influences, and we're going to be looking at the second influence on human resource management, and that's legal, the current legal framework. Now it's a pretty big syllabus dot point with lots of things that we need to be addressing and looking at and chatting about, so it'll go over this lesson and next lesson. Today's lesson will take a look at the employment contract under legal, the current legal framework. That's the dot point. Again, legal, the current legal framework, and it's basically the law and all the things that fit under the law. We look at the employment contract, common law, rights and obligations of the boss, the employer and the employees, and common law is court-made law for simplicity's sake. We'll take a look at minimum employment standards and minimum wage rates, awards, enterprise agreements, and also other employment contracts. Again, all of these are examples of legal, the current legal framework. Next lesson, we'll still be looking at that major heading, but we'll be looking at things like equal employment opportunity, and discrimination, workplace health and safety, that sort of stuff we'll be looking at next lesson. All right, now, what's an influence? Something that has an impact upon the business. So you need to be able to, like I've talked about before, define each of these dot points. That's the sort of lower order stuff. Then you need to be able to better explain how these dot points, i.e. the law, legal, influences or impacts upon a business. Now, legal, it refers to laws made by Parliament. This is called statute law. You need to think of the Prime Minister, the Premier, and legislation being created. The Fair Work Act as an example. But it's also legal talking about common law decisions. That's court-made law. Okay, stuff that's made through this thing called the doctrine of precedent. Now, if some of you do legal studies, this is probably familiar to you. We don't look into that much depth in it, but it's court-made law. All right. The general trend that we're seeing in terms of the current legal framework is to move from a centralised system of negotiation between unions and the employer to a more individual negotiated employment contract between the boss and each individual employee. And this hasn't totally happened, but we're seeing this trend occurring. All right, now what do we mean by a centralised system? It sort of talks about back in the day how unions were predominant organisation in human resources, and they would represent the employees and they would negotiate against the employer. They'd, fight it out, and it would be an external body, often called the Industrial Relations Commission, Australian Industrial Relations Commission, or the New South Wales Industrial Relations Commission, that would make a decision about pays that people would get. It was decided by one organisation as such, why it's centralised. These days, though, we're seeing much more individualised, tailored employment contracts, especially when people start to earn a little bit of money, or if people are on individual common law contracts and as soon as contractors. Okay, the current legal framework. This is what it's about. It's what we use now, and it's a law that we need to follow. It's what employers and employees, the workers, are legally entitled to. Now, the current legal framework, it's governed under a piece of legislation. Does anybody remember what that legislation is? If you guess Fair Work Act, then you're doing well. The Fair Work Act, it's a Commonwealth piece of legislation. Now, this Fair Work Act sets out 10 minimum standards, a safety net for employees. Some of these standards include the minimum weekly hours a worker is to work, flexible working arrangements for parents who need to manage children and work, parental leave, annual leave, that's like your holidays, compassionate leave, that's for funerals and things like that, community service leave, long service leave, public paid holidays, etc., etc. There's other ones that we'll look at in class. Now, again, I talked about how is this an influence? It's an influence because employers, the boss, must comply with this current legal framework. They can't just not give somebody annual leave. they have to give them 4 weeks minimum annual leave unless the person's getting paid a huge amount of money and they can kind of trade off some of these weeks. But generally that's what it's considered. They have to follow and comply with it. So therefore it's an influence. It's an impact on the employer and HR. Now, one of the first things we take a look at under the current legal framework is the employment contract. Now, an employment contract must follow common law, it's court-made law, and statute law, parliament-made law, like the Fair Work Act. They can be either a contract of service or a contract for service. Now, we'll talk about that a little bit later on, but a contract of service is the usual thing you're used to. The boss, the worker, the standard employer-employee relationship. Also, a contract could be a contract for service, which could be like a contractor, an electrician or somebody coming in. They there have to do one job or a couple of jobs, and it's not the usual employee relationship. It is a contractor. Now, it's an influence because the boss, the employer, must enter into an employment contract with the employees. That's the law, and it sets out the conditions and the requirement of the contract. Hence, the fact they've got to do this is an example of the law impacting or influencing on human resources. Now, the next dot point we take a look at in terms of current legal framework, is common law. And this is often a question I've seen plenty of times in the HSC and trial exams. Who knows what will happen this year, though. This is court-made law. It's not law made in Parliament. It's called common law. And we're looking at rights, things you get, and obligations, things you've got to give to, for other people to get those rights, of the employer and the employee. Now, some of the obligations, the things the employer has to do, is to provide a duty of care. This means that it's the boss's, the employer's role to make sure that everything is safe, e.g., complying with WH&S. The boss also has to pay the agreed wage. They have to forward PAYG tax to the ATO, and they've also got to make the required super contributions. In a test, if you're asked about this, these are the things you need to mention directly. Now, some of the obligations of the worker, the employee, is to follow lawful and reasonable instructions, to use duty of care when performing your duties, to act faithfully in the employer's interests, i.e. don't assist a competitor, don't bitch about them too much on Facebook and social media, provide the employer with a process or product developed while employment. And this is very important for researchers. You develop some type of new medical treatment and you're working as a science assistant, you can't take that with you. It is the boss's, not yours. It's the company's. Now, again, the law influences HR in this instance because it's a law that forces, influences employers and employees to follow their responsibilities. Now, I did say it was a big topic, so I do apologise. It goes for a while. The next one under this legal framework is minimum employment standards. Okay, NES, National Employment Standards, is another way of saying this. And it's very, very important that you know this. Often this comes up in terms of assessments. Fair Work Act sets these out. There's 10 minimum standards. Now, I've mentioned them briefly before. They're minimum weekly hours that are prescribed, flexible working arrangements, paid public holidays, 4 weeks notice of termination. You can't just sack somebody unless it's serious summary dismissal, and up to 16 weeks redundancy payments, depending on how long the person's worked for the business. Okay, how are these influences? Well, if you've got to follow and comply with these laws, a boss does, which they do, then that's a heavy impact on you in HR. All right, we're getting there. Minimum wage rates. Now, this is the minimum wage you may have heard about before. It's the lowest that you can possibly be charged. Okay, and we talk about the minimum wage currently at being $18.29 per hour, or based on a 38-hour week, $694.90. But good kids, you do need to make sure you're having a look at that or come see me for the most up-to-date statistics because it does change each year. Now, the award, you may get paid more than the minimum wage. I'm going to talk about an award in a second. But if your industry does not have an award, then the minimum wage protects you. You can't pay lower than that in Australia. Again, how is this an influence? Because businesses must pay this minimum wage, which is pretty high compared to other countries. It has a negative impact on human resources. It costs more. But getting paid these higher wages compared to America means that our workers are generally more productive at that level. Now, the next thing we've got is an award. An award is a minimum rate of pay and conditions for all employees working in a specific or particular industry. It sounds similar to the minimum wage, but it's not. Minimum wage is if there is not an award, and awards are always generally higher than the minimum wage, but they're for particular industries, i.e. teachers aren't on a minimum wage because we've negotiated an award. We get paid a certain figure. Let's say the award per year for teachers minimum starting out, I think it's about $67,000. Now the minimum wage is roughly about $38,000, $39,000. So which ones are teachers on? If you guessed the award, you're right, because if it's higher, then you go with a higher one. A cleaner, on the other hand, generally doesn't have these high level awards, and so they'll be on a minimum wage instead. Now, enterprise agreements is the next one we look at, and it is the second last thing. Enterprise agreements are what we call collective agreements or certified agreements. Enterprise, collective, certified agreements all are interchangeable. So if you hear these terms, understand that. Now, it's usually a union involved, but it's when you have the whole enterprise or the whole union negotiating with the boss as a group. It's generally better for the employee. Employers don't like this so much. Now, in terms of an enterprise agreement, the union usually, not always, will represent their workers, hundreds, thousands, tens of thousands. In the Department of Education's example with the New South Wales Teachers Federation, literally hundreds of thousands of people are represented by the New South Wales Teachers Federation, and we set out our enterprise agreement. The union consults its members, us teachers, and figures out what we would like to see as a pay increase in our conditions. They then negotiate with the Department of Education, our employer, and then hopefully, without industrial action, they'll arrive at an agreement. The union come back to us and check whether we're happy with that. Hopefully we say yes. And then what happens is the final step to make sure that the union isn't ripping off the workers, even though they're always meant to help the workers. There's been issues with the SDA, which worked for Woolworths and Coles doing that before. It goes to Fair Work. They apply a thing called Better Off Overall Test, Fair Work Australia do, to see if workers are better off now under the new enterprise agreement than what they were under the previous agreement. If they are, tick, all good. If not, it will not be passed, and negotiations will begin again. Again, the same thing. How's it an influence? Well, it's an influence because it generally results in greater costs imposed upon businesses, and that has this negative impact on human resources. Now, the last one we look at today is other employment contracts. It's very important. We look at permanent part-time versus permanent full-time versus casual, and this notion of fixed-term contracts. Now, permanent contracts is where a person is working between 35 and 38 hours per week. They're entitled to benefits under their relevant award. Now, part-time contracts, they're also called permanent part-time sometimes. These are exactly the same as permanent full-time contracts. The only difference is that it's pro rata. Now, some of you may have heard pro rata before, some may not have. Pro rata says that if you work, say, half of the 38 hours, which would be 19 hours per week, then you're entitled to 50% of the long service leave as a full-time worker, 50% of the sick leave, 50% of maternity leave, etc., which makes sense. All right, the next other employment contract that we have are for casual employees. Now, casual employment contracts refer to workers who are employed on a random basis and therefore do not receive any benefits such as sick leave, long service leave, annual leave, etc. But they are looked after in a way. They receive up to 1.5 times the wage of a permanent worker. And often in my job as head teacher admin, I have casual teachers who may or may not go on temp contracts. Temp means like permanent. Casual is, day-to-day stuff. They say, should I go on casual or temp? And I say, it really doesn't make much of a difference. Casual teachers get paid more per day, but they don't get paid during the holidays. If they're crook, they don't get paid sick leave. So that's why they get this casual leave loading of up to 1.5 times that of a permanent worker. Now, fixed term contracts, these are contracts that people are on who are on a contract for service. Remember I mentioned at the start, contract of service? That's an employee, someone doing a standard job. A contract for service is somebody like an electrician, plumber. They're providing a service for you. It's known as a contract for service. All right, now all of these contracts are set out by law and hence have a massive impact, again, on human resource management. Okay, guys, thanks for listening. See you in class.